Hi, bankruptcy attorney Brian Barboza here, and today I'm going to discuss, are you able to keep your car if you file for bankruptcy? Before we get started, if bankruptcy is something that you are interested in exploring or talking more about, please feel free to give me a call or go to my website, barbozalaw.com. I'd be happy to speak with you for free. Just book an appointment directly through my website. Okay, so can you keep your car if you file for bankruptcy? This is kind of a complicated question, and there's a couple layers to this. The real answer is it depends. Okay, so first, let's talk about layer number one, which is the relationship between you and your car loan company or your car lender. So the question would really be, will your car loan company take your vehicle, repossess your vehicle, if you file for bankruptcy? And the answer, again, is it depends. So what happens is when you file for bankruptcy and you eventually get your discharge of your debts, you are no longer personally liable for that car loan. You're no longer personally liable, but they have a lien against your car. So if you don't make your car loan payments, they can come and repossess that vehicle because you're going to exercise their rights under that lien. Okay, so the issue becomes, if you are still making your regular monthly car loan payments during and after your bankruptcy case, can the lender come and take your car? In California is situated in what's called the Ninth Circuit. It used to be that as long as you could what we call retained and pay, or pay and retain. So the law changed, unfortunately, a while back, and the courts have said that even if you're still making your car loan payments on time after your bankruptcy case, the lender could come and repossess your car unless you enter into what's called a reaffirmation agreement. Reaffirmation agreements are basically contracts or written agreements between you and your lender that you'll continue to pay. You'll still be personally liable on the debt, and in exchange for that agreement, they can't come and take the car so long as you're making your car loan payments on time. That agreement also has to be approved by the bankruptcy judge. I always advise people, don't enter into that agreement. It's a terrible idea, and here's why. Most of the time when I meet with people, they owe more on the car than it's worth. So they're actually signing up to be personally liable on a vehicle that's worth less than what they owe. And in the event they find themselves in a position after the bankruptcy where they start missing payments, or they can't make their payments, or the car breaks down and it's super expensive to fix and they don't want to fix it, or you get in a wreck and you total your vehicle, that lender is going to sue you for the money. You're not going to pay for the car if it's no longer operating. You're going to probably give it back to the lender. But guess what? You signed a reaffirmation agreement. You aren't personally liable. They're going to sue you for that money. Whereas if you never signed that reaffirmation agreement, you would not have been personally liable for the debt. They would not have been able to sue you. So most of the time, my personal observation has been, as long as you keep making your car loan payments, the lender, they want the money, they don't want the car. They're usually a bank or a lending institution, and they're not a car sales company, so they don't want the car. They usually are happy as long as the payments show up on time, letting you keep the car. Not always. Once in a while I've heard stories about a lender coming and taking a car even when someone was post-bankruptcy current on their payments. But most of the time my experience has been the lenders are happy to get the money and they don't come and take the car. So my advice is usually don't sign a reaffirmation agreement. Just expect that as long as you make your payments, the lender won't come and take the car. However, if they do come and take the car, so what? Usually you don't have any equity in the car. You owe more on it than it's worth, so you're not really losing anything, and you can go out and buy the same car for less money. So it's not the end of the world if the lender did want to come and take the car. And that's what would happen between you and your lender. Now, the other layer to this is, could the chapter, if you file what's called a Chapter 7 bankruptcy case, and there's what's called a Chapter 7 trustee that's in charge of the bankruptcy case, and their job is to look at your property and see if there's anything he or she can sell for the benefit of your creditors. And that question is going to depend on how much equity is in your vehicle. There is some equity protection for a vehicle in a bankruptcy case, which then would protect it from the trustee selling it. But that equity protection, we call these exemptions, is very limited. So there's a limit to how much you can protect in a vehicle. And it also depends on which exemption scheme you can use in your bankruptcy case. There's two exemption schemes in California. One gives you a lot of personal property protection. So in that scheme, you probably could protect your vehicles. However, if you own a home, you're going to want to use the other exemption scheme that gives you a lot of home equity protection, but that one offers very little protection for things like vehicles. So again, it depends on how much equity you have and also what other assets you may own at the time you file your bankruptcy case. Bankruptcy is really complicated. If you do intend to file bankruptcy, you're going to really want to talk to a professional like myself to determine what you will potentially lose in a bankruptcy case, or what you can protect. The alternative to Chapter 7, by the way, there's also called a Chapter 13 bankruptcy. That is not a liquidation bankruptcy. In that kind of bankruptcy, you do not lose property, but the trade-off is you will be making a monthly payment for 36 up to 60 months. And at the end of the last payment, you get your discharge. However, the nice thing about Chapter 13 is they're not looking to sell your stuff. So there is an alternative to Chapter 7, that Chapter 13, where you are not at risk of losing any of your property. Okay, that's it. Again, if bankruptcy is something you want to talk more about or you're interested in exploring, please feel free to give me a call. Go to my website, barbozalaw.com, book an appointment to speak with me for free directly through the website. As always, thank you for your time. I hope you got something out of this video. Hope it was helpful, and have a great rest of your day. Thanks.